Unlike in many countries where executive plays a dominant role, in India, judiciary has a primacy in the judicial appointments through Collegium system, which is headed by Chief Justice of India along with senior judges. Hello everyone, this is Prathyusha. Welcome to Law Excellence. In this session, we're going to discuss about various aspects regarding the Collegium system. When we come towards this topic, why it is in use? Recently, we have observed that 2 new judges for the Supreme Court have been appointed through the Collegium system. Now, the strength of the Supreme Court judges has been very close to the sanctioned number of 34 judges. Now, when we see where is this Collegium system and how it has been developed, did we have any background, how the evolution has been taken place? Originally, Collegium system is not been present in the Constitution, where it has been evolved through the different cases by the Supreme Court. Now let's see the appointment of the judges. Now when we see the Supreme Court and the High Court, appointment of the judges is being done by this Collegium system, where the Supreme Court is where it is being headed by Chief Justice of India and 4 senior most judges, whereas High Court is being headed by the Chief Justice of High Court and the 2 senior most judges. And whatever the suggestion that is being given by the Collegium system, now that suggested judge will be appointed formally by the President of India. Now let's see how did this Collegium system has been evolved. What are the different constitutional provisions have been present? First, when we see, we have Article 124, where the appointment of Supreme Court judges is being written in the Constitution after consultation. Now, this word consultation in the Constitution has led to the different interpretation, which led to the different judges' cases, which led to the development of the Collegium system. Now, when we see Article 217, here it gives a provision for the appointment of the High Court judges in a similar manner. Now when we see what is the first judge case. Now a first judge case in 1987, it is between S.P. Gupta and the Union of India. Now in this judge case, Supreme Court held that the word consultation does not mean concurrence. It means that now when the Supreme Court has been asked for the advice about the appointment, so whatever the name that is being given by the system, now this name may not be accepted by the executive, may not be appointed by the President of India. Now this is where the primacy, the ruling or the decision making part is being given to the executive. Now when we see after this, in 1993, we have the second judge case has been come up, where we have Advocates on Record Association versus Union of India. Now this verdict has overruled the first verdict, where there we have given the executive was given the primacy, whereas here in the second judge case, Collegium was being established, where it has told that CJI with the 2 senior most judges will make a Collegium system. Now they will be providing the names, they will suggest names for the appointment of the judges for the Supreme Court and the High Court. Whereas in the third judge case in 1998, now this was come with the presidential reference under the Article 143, where the President will be asking the Supreme Court for the clarity on the different issues. This has expanded the Collegium to CJI and the 4 senior most judges. Now this is the one that's being present. But you might also remember we have one more NJAC Act that has come up in 2014, where it also been struck down in 2015. Now this National Judicial Appointment Committee replaced Collegium in 2014. It was passed by the Parliament and it was a body including both the executive and also the civil societal members were being included in selecting the judges for the Supreme Court. But this has been struck down by the Supreme Court in 2015, saying that it is an unconstitutional, where it has been violating the independency of the judiciary and it has been affecting the basic structure of the Constitution. And again the Collegium system has been restored. Now when we see what are the concerns regarding the Collegium system? Now when we see the concerns, first one is is lack of transparency. We don't know what has been done or what is been going on regarding this committee, in what criteria they have taken, what is the merits, demerits, etc. is not been open to the public. We don't have any minutes of the meeting published. Then we have accountability issues. There's even in the recent current affairs, you might have seen that there are articles saying that these two judges were being selected for the Supreme Court based on nepotism. Now that is also an allegation that's been coming up. Second one, due to this, we find delay in the appointments. Almost 30% of more High Court judges vacancy is being present because of the two things. One, delay in the suggestions from the Collegium system and the appointment by the executive. Then we have executive and judiciary tussle. Now who is going to get appointed as the Supreme Court judges or the High Court judges? Then the constant tussle between the judiciary and the executive. Lastly, regional and social representative. There is concerns about inadequate representations from the particular region or particular social community group. Now when we see what can be done or what are the different ways how this Collegium system can be reformed more. First thing, we have to have a transparency. Now we already know High Court, Supreme Court, they are going with this transparency where they have included the live sessions in the YouTube and in the websites. Then even this we have to increase. Even the Collegium system, the meetings that have been there, what criteria they have been using. Are they using the merit? Are they using the representation or the seniority? What is the criteria for the selection of the particular judge? Then we also have to have minutes to be published to the public. Then we have timely appointments should be ensured by the Collegium system. We have to have balance of independency with the judiciary, and the accountability should be there. And we also have to reform the National Judiciary Appointments Committee like model. So yes, if this is unconstitutional in nature, we can come up with another reformed NJAC where the executive and the civil society will take part. We will know what is the criteria for the judges that are being selected in the Supreme Court and the High Court. Now let's see the practice question. 1. Consider the following statement. Collegium system is explicitly mentioned in the Constitution. Second, third judge case expanded the Collegium to the 5 judges. NJAC Act in 2014 was struck down as unconstitutional. Which of the following are correct? 1 and 2, 1 and 3, 1 and 3 only, 2, 1, 2, 3. So please comment the right answer in the sections. Now let's see the mains question. Collegium system of judicial appointments in India has ensured judicial independency but also has invited criticism for lack of transparency and accountability. Discuss. Now what all we have discussed in this session, right from what is this Collegium system, what is the process involved, and how did the evolution of this Collegium system occur, how it ensured the independency of the judiciary. Then in the second one, what are the challenges that are being present, what are the concerns regarding this Collegium system, and what can be done. Now this session can be utilized in answering this question. Thank you everyone. Let's meet next time with another interesting topic.